Ms. Sheff, I'd like to kind of pick up where we left off before and just talk about what we need to do to solve the problem of burden shifting. What would be the ideal kind of legislation as you would envision it, and how would it change the burden?
Sure. At initial step, the administrative forfeitures should be wholesale revised. The burden should not be on property owners from the beginning to respond to an agency with a direct financial interest in the outcome of this. When property is taken, it should be the burden of the government to file, at least take the initial step and show, file a complaint in federal court, just like all other civil proceedings. Beyond that, once the standard of proof in civil proceedings should be elevated from mere preponderance of the evidence to clear and convincing. And then the government should also bear the burden of showing that the property owner knew about or consented to the illegal activity. Under this regime, there would still be an affirmative defense for innocent property owners like Mr. Caswell to show that they took all reasonable measures to mitigate that or to stop the illegal use of their property. But the burden should not be on them to prove a negative that they did not know about something.
Now, under the status quo as it operates, in your experience, how hard is it generally for an innocent person to get his or her property back once it's been seized in a civil asset forfeiture proceeding?
It's very difficult. It's extremely hard because, as I testified before, the deck is stacked against property owners. You're not guaranteed counsel, and often the property is worth less than the amount of legal fees. The agency will immediately start administrative forfeitures, and the burden is on property owners to timely file a claim. There have been numerous reports of even the notices that property owners get are unclear. People don't know what agency of all the, between the state and local that sees their property, where are they supposed to file this claim? And there's no good cause exception. If the property owner misses that deadline by a single day or even just minutes late from the filing deadline, it's administratively forfeited, and that's it. If they're lucky enough to survive all these loopholes and make it to federal court by timely filing a claim, then again, these burdens are still stacked against property owners. And even in the end, they might be able to recover attorney's fees, but that provision has also been gutted. And so very frequently, property owners do not actually recover their attorney's fees under CAFRA. So it is a system that is stacked against property owners, and that needs to change.
And just to be clear, you don't, I take it, have any problem with the government seizing property that was involved in a crime, seizing property from someone who was involved in a crime and where guilt is adequately proven.
Right, and that is criminal forfeiture. Nothing that we're talking about today or that the Institute for Justice recommends is changing criminal forfeiture. This is all pursuant to civil forfeiture, this archaic legal fiction that property itself that can't act or think is somehow guilty.
Right. My understanding is that some trace the civil forfeiture laws that we have today back to what was known at common law as the deodand, which was based on a theory that an object that was used in killing somebody, sometimes by accident, needed to be forfeited and seized, in part because of a superstition that it was evil. The thing itself was evil. Do you share that view, that that's sort of where it came from?
Yes, that's exactly where it came from. It was this medieval origins, a superstitious belief that objects independently acted to commit crimes. In the U.S., civil forfeiture traces its origins to the practical necessity of obtaining jurisdiction over property when the owner was overseas or wasn't available to have jurisdiction over. And that justification is no longer true. There are many cases, the people that we're talking about are right there. Courts have jurisdiction over the person and can bring a criminal forfeiture action. Even during Prohibition, which expanded forfeiture, it was limited to instrumentalities, so the vehicle that was transporting illegal liquor. It was not this catch-all of all property, no matter how tenuously connected to a crime. And the Supreme Court has made clear over and over again that forfeiture is drastic. It is not favored. In fact, it's a draconian method. So we do need to rein it in from the 1980s and this constant expansion and proliferation.
Okay. Thank you very much.